Thank you for joining us today. My name is Jeff Worley, and I'm a partner at Gibble, Crable and Hess. Today, we're going to be talking about power of attorney documents. I'm in the corporate practice group, and I don't know a lot about power of attorney documents and what they entail. And so I've asked my colleague and partner, Ann Martin, to join me today to discuss this important topic and its relevancy for what we're going through right now during this COVID pandemic. So Ann, I'll turn it over to you to introduce this topic for us.
Thanks, Jeff. So many of us are expressing gratitude at this time to our frontline healthcare workers. We're doing that by providing them with meals, putting up yard signs, we're writing letters to the editor, we're banging pots and pans together on our front porch and telling them how much we appreciate their work, and appropriately so, because they are putting their lives at risk to care for us. But they are also speaking back to us, and they're telling us some ways that we could make their jobs easier. I was struck by a recent story I heard from a doctor in a COVID-19 unit who talked about a 30-year-old patient of his, a young man, who did not have in place any documents that would indicate what he wanted for his end-of-life care if he was not going to recover, nor had he specified who his agents for healthcare decision-making would be. So his father and his mother were left in that position by default. Father understood his son's situation and did not want extraordinary interventions. Mother wanted to try everything possible, and this put his parents at odds with each other, and the doctor described this as an incredibly heartbreaking situation, and it could have been avoided.
And when we look at these documents and their importance, and by the way, I do have my power of attorney documents in place.
Good.
Thanks. But one of the questions I'm hearing is, I'm married, so isn't my spouse just automatically my agent for any health or financial decisions? Do I really need to put something in writing?
That's an excellent question, and it's one that many married folks are asking. Unfortunately, even being married does not give your spouse an automatic authority to handle your financial decision-making or handle your assets, or to transfer or sell even assets that you own jointly with your spouse. And because we're focusing today specifically on healthcare decision-making, it's really important for you to also, in writing, specify your spouse as your primary agent for healthcare decisions if that's the person you choose. In Pennsylvania, if you do not appoint your spouse as your agent for healthcare decision-making in a document, there is a default statutory order of priority that will say who gets to make healthcare decisions for you if you haven't otherwise spelled that out. But depending on your family situation, the default agents might not be the ones you would have selected, and it might not even be clear who gets priority. So let's say you're married, Jeff, but it's a second marriage, and let's say you have adult children from a prior marriage. Your current spouse and your adult children from your prior marriage would have equal authority, and that may or may not work out so well depending on your situation. So that's one thing. If you have agents who are by default given the task of making healthcare decisions for you because you didn't put anything in writing, and they've never had a conversation with you about what you want, and they have no clue, they have no written document saying what you did want, it's really a tough spot for you to have put them in. And moreover, if you have several agents who have an equal priority under that default statute, and they're in conflict, as were the mother and father of the young man that I just referenced, that's a really avoidable, heartbreaking situation.
Mm-hmm. And also it comes back to making sure that you're getting what you want as somebody who's maybe doesn't want those measures put in place, or maybe somebody who really does want to make sure those measures are in place.
Exactly.
A lot of people are asking, well, I'm young and healthy. Aren't power of attorney for, older people, but people who are at risk? What do you have to say about that?
Well, I personally know quite a few folks in their 30s and 40s who have become seriously ill with infected with the coronavirus, and that's the specific healthcare situation we find ourselves now in. So that's the example I use. So my response is no, it's not just for older people. Everyone over the age of 18 should have both a financial power of attorney document in place and should also have a healthcare power of attorney document in place. And the story again that we referenced at the outset was of a 30-year-old young man who passed away after spending time on a ventilator. So this is not just something that we are suggesting older clients do.
And this is also not something we would just necessarily suggest during the pandemic either, right?
Correct. Correct.
So what exactly does a living will do?
So a living will is a document that expresses your wishes about what kind of end-of-life healthcare interventions you would want or not want if you become unable to verbally communicate your own wishes or to process information that's presented to you about your options. If you are unable to express yourself and you are permanently unconscious or in an end-stage medical condition, a living will is your way to communicate what you do or don't want as far as medical interventions if there's no realistic hope of a significant recovery.
And what is a healthcare power of attorney?
So that's a document that would appoint people as your agents to make healthcare decisions on your behalf. That could be in an end-of-life context, or it could even be in a case where you're just temporarily unable, like say you're coming out of anesthesia after surgery. You're temporarily unable to make or communicate decisions about your own healthcare wishes. So those two documents work really well hand in hand, and in our firm, they're actually combined in one document. We call it a living will and healthcare power of attorney. And I think you can imagine how great a help it would be to agents for your healthcare decision-making to see in writing your living will wishes.
What are some of the things that someone would have to decide in order to complete a living will and or a healthcare power of attorney?
So I guess I hinted at them in my response to that prior question. You will have to decide whether you want to indicate if you would want extraordinary medical interventions withheld or withdrawn or administered. If you are unable to communicate your wishes, you're permanently unconscious or in an end-stage medical condition and there's no realistic hope of your recovery, you would indicate who do I want to name as my agents for healthcare decision-making? And if I name more than one person, do I give them equal authority and say they can each act individually, or do I require that they must agree? You can talk about your preferences for organ donation if that's relevant. You can list specific actions that you authorize your agents to do, and you can get quite specific about certain interventions that you are okay with and others that you would not want if they are, solely aimed at prolonging your inevitable dying process. You have the chance to say, please do not, do those things if there's no point and they're just prolonging the inevitable.
So this sounds like a pretty nuanced process and not a one-size-fits-all.
Right. You want to think through scenarios and decide, for yourself, not just probably take a boilerplate document and sign it.
And so we see a lot of these online, and probably for most folks, that's not necessarily going to work because each situation is going to be different. Everybody's going to have different wants and needs, and it's not simply check this box or check that box kind of response.
I certainly think that the conversation with an attorney who is licensed in the state where you are currently living, it's important to have that conversation with an attorney who knows, for example, Pennsylvania law regarding financial power of attorney and living will and healthcare power of attorney documents, because they do vary state to state.
Well, another thing people are questioning is that, can I just name agents for financial and health care decision making in my will? I mean, my agents are basically the same as an executor. That's a common misperception that we're seeing as well?
So you can name the same people to be your agents for healthcare and or financial decision making as you name to be the executor of your estate, but they're very much not the same role and they're not the same document. And those roles in those documents have effect at very different times. So an agent for financial and healthcare decision making can only act as long as you're alive. Those documents become moot. If you pass away, they have no more effect. In contrast, the executor of your estate, of course, can only be appointed and begin to act after your death. So no doctor who is caring for you, in a critical care unit is going to say, does this person have a will where I can look and see who Ann's executor is? Those two things just aren't going to mix. So it's really important that you put in place the lifetime documents, the power of attorney documents for financial and healthcare decision making. Yes, by all means do a will too, but that's really an after death kind of appointment. And we're talking now about lifetime decision making.
Mm-hmm, mm-hmm. Well, I think that's all really helpful and gives us some basic ideas about this topic. As any attorney will tell you, each situation is going to be different, and so you folks out there who are watching this should consult with your attorney and not rely on this as legal advice. But certainly, our recommendation is that you do seek out an attorney to have these documents prepared. Any final thoughts on this topic, Ann?
I think a lot of us are spending a lot of time at home and with our loved ones, and we're getting a lot of our affairs in order, taking time to kind of tidy up and organize our lives. And I would add getting good power of attorney documents in place to your to-do list if you are trying to take advantage of this abnormal time. You really do owe it to yourself and your family. And I think you owe it to those wonderful frontline healthcare workers who are, trying to figure out what your wishes were, and you could really do them a solid by giving them an indication in writing, and your family members as well.
Well, thanks a lot for spending some time with us today, Ann. As I mentioned at the outset, Ann and I are both partners at Gibble, Crable & Hess, and we are available for any of your legal needs. Our website is gkh.com, and we're happy to talk with you about your powers of attorney or any other legal matters you might have. So thanks for joining us, and be safe and be well.
Thanks.